6:40 in Trinidad and Tobago. So many things in the politics. I even forgot to ask Minister Khan for his reaction to the passing of a long-time PNM stalwart and former PNM cabinet member Errol Mahabir, who passed away over the weekend at the age of 84. Hopefully TV6 News will have the opportunity to get some different reactions as his passing occurred over the weekend. But there's another issue in the politics, this matter of the United National Congress filing its election petition in the High Court to challenge the decision by the EBC, the Elections and Boundaries Commission, to extend voting on September the 7th in Trinidad only from 6 p.m. to 7 p.m. We have with us on the line Attorney at Law Martin George, who's, by the way, a member of the Police Service Commission, but he's speaking to us in his capacity as an attorney at law to give us a perspective on this matter. Good morning to you, Mr. George.
Yeah, hi, good morning to you, Fazil, and good morning to your listeners.
Thank you very much for joining us. What is your perspective on this particular matter that was raised by the UNC?
Well, Fazil, I think that it is going to face the greatest evidentiary hurdle, because at the end of the day, if you are claiming that you have in some way been disenfranchised or discriminated against or prejudiced, or you have suffered some detriment, then the onus and burden of proof lies on you. So in other words, it is not simply an esoteric or theoretical argument to come to the court and say, well, we feel the EBC should not have extended the hours, and we feel that as a result we have suffered and may have lost certain seats. You must be able to convince a court by way of evidence to show that you have actually been prejudiced. And no matter how you cut it, slice it, dice it, no matter how you twist it, turn it, or spin it, it is going to eventually come down to that issue of the evidence, which I would respectfully assume would present the greatest of challenges for anyone to produce. Who can say at 6 p.m. what was the vote count or the vote tally for either side? So you will always have that difficulty. It will always end up being a speculative exercise. And once a court recognizes that there is no evidential underpinning to support a matter, it doesn't matter how many legal issues you can argue around the point. If you don't have the evidence at the end of the day, I think it's going to be stillborn from the get-go.
Well, while we're slicing and dicing, let's throw in some onion and garlic and saute it a little bit, because if you understand what the UNC are saying, they are raising the issue not just about the claim, if we can call it that, of whether or not they were in the lead or not at 6 o'clock. They're also raising the issue of whether or not it was proper for the EBC to extend the voting in the manner in which they did, and whether it raises the issue of the procedural action of the EBC in that matter.
Right. Well, the point is, Fazil, when one looks at the Constitution and you look at Section 71 and you see the wide powers and discretion which are conferred upon the EBC, which basically allows them to have a fairly unfettered jurisdiction to conduct the polls, unless there is some element of manifest unfairness that you can show that you have been particularly, so it will still come down to that issue. So in other words, all right, if you want to challenge and say, well, they exercise their powers capriciously or injudiciously or in a wrong manner, now you bear in mind the backdrop of what the Constitution allows them to do. So then now you must show a court that, look, I have been particularly prejudiced and this has been specifically unfair to me by the way they have exercised those powers, so therefore I have a basis for making a complaint. So one has to look at it in that context, and it will always come back down to that, because the law gives the EBC that wide remit to conduct the elections. And if it is that they extended the time in 39 constituencies, I think this petition also faces a hurdle in that it appears they've only filed their claim in respect of 6. Why are you selecting 6 constituencies to say that, look, you are only challenging their decision in respect of these 6? it does not seem to make any sense at all, because when they extend the time, they extended it for all 39 constituencies in Trinidad. So therefore, you cannot cherry pick 6 of these and say, well, look, I am choosing these 6, unless you can show what your vote count was at 6 p.m. to say, well, look, I was ahead. So it will always come back to that. And I don't think, and I say this with the greatest of respect and deference, because, of course, one always has to have the highest regard for legal arguments that people will make. But it does not appear, respectfully, that anyone, not even the EC, would be able to have that information to say what the vote count was for either side at 6 p.m.
Just on a couple of points there, and I think we'll have the time to just expand them a little bit. But just on the issue, as you talked about, why challenge in only 6? Doesn't that make sense? Because rather than waste time going over 39 constituencies, it's the 6 constituencies that decided the election, so you might as well deal with that straightforwardly.
No, because you see, remember, if you are saying that the basis for the challenge is the fundamental power of the EBC as to whether the EBC can extend time at all, they didn't only extend time in 6 constituencies. So therefore, if you are challenging it, then it would seem logically you are challenging the fundamental basis of their power to extend time, which is in 39 constituencies, not just 6.
But
Follow me, the only way you can then now cherry pick to take these 6 out is if you present some evidence to show, well, in these 6, I was particularly prejudiced. Now, the fact that you lost those 6 seats is not the prejudice. You must show that you were actually ahead at 6 p.m. How do you establish that? You see, that is where the difficulty lies.
Doesn't it?
Because remember, the extra hour for you, it operated across the board. So in other words, voters from one party could have voted in the extra hour, voters from another party could have voted in the extra hour. It was across the board. It wasn't that time was extended for one side and not for the other. It was extended across the board.
Isn't the data, and I think this is probably the key issue, and again, it might be an issue of analyzing things to the death at the end of it all for no apparent purpose, but isn't the data available that could allow, if the investigation was called for, to actually determine what was the vote count at 6 p.m. in the various constituencies?
Well, if you have a method of doing that, I'll be happy if you can share it with the media.
No, I'm just asking because
because if you think of it logically, there's no time stamp on someone's vote. Okay, so on your ballot paper, there's no time stamp. Okay, there's no time record of when you would have come to a polling station to cast your ballot. If you understand me,
yes.
There's no record to say who you voted for. Remember, the rules of the Representation of the People's Act prevent persons from, inquiring into who did you vote for and stuff like that. In fact, they make those things criminal offenses. You're not supposed to, try to force anybody to declare who they voted for or anything of the sort. So when you look at it, from any which angle you approach it, you are going to be stymied in terms of your evidence, and that is the fundamental issue here.
And if it is so straightforward, Mr. George, forgive me for just saying Martin George, but
no, that's fine.
If it's so,
I don't stand on ceremony.
I know that. Even though I'm sure you're going to procession and thing on Wednesday and so on, but you don't let that go by. But if it's so straightforward and it's going to be so extremely, extraordinarily difficult to even present an arguable case, why pursue it?
Well, the point is, there's nothing to prevent a litigant from seeking to explore all means possible to test the limits of the law, and that's how your jurisprudence develops. So there's absolutely nothing wrong with trying to bring such a case or pursue it. But the point is, as I say, regardless of all the beautiful legal arguments and all the niceties of the law which you can explore, it is going to eventually come down to the evidence. So even the grant of leave, I will explain this in a way that I think can make it simple for persons to understand the significance of a grant of leave. Grant of leave is like you taking a key and a lock. You might be able to fit a key into a lock. That is what the grant of leave is. But not every key you fit into a lock is able to turn that lock. And that is what you require thereafter to prove your case. So the proving of the case is actually being able to turn and open that lock. So the grant of leave, while it does establish that, yes, your case fits into the type of category that the court will allow you to bring, that's as high as it goes in terms of the grant of leave. So, I mean, while, of course, yes, it is a cause for celebration, you know, for the, those who filed the matter, it is, I mean, in legal circles, we know that, look, it's just, you're trying keys in a lock. Okay, yes, this key fits in the lock. Does it have the ability to turn the tumblers inside that lock? If it doesn't, then your case goes no further.
Mr. George, thanks very much for that analogy. Although, just to sweeten things a little bit, it might be a combination lock and you just guess the correct numbers and you open it up. But anyway, thanks very much for chatting with us this morning. Attorney at Law Martin George giving us a perspective. And yes, maybe some levity to what many will say is a very, very serious situation. Who knows? Will this actually, at the end of it all, even if the UNC are not successful, will it raise an issue constitutionally as to whether or not the remit of the EBC, as referred to by Martin George, is very, very wide? Will that now have to be narrowed to ensure that such situations are understood clearly? And will it actually result in a reframing of the remit of the Elections and Boundaries Commission? 6:51 in Trinidad and Tobago. We'll take a break and come back as we continue up towards 7 o'clock on this Monday morning.